Letter G is where we're at, the referral. Managing brokers are authorized to participate in a referral program. The client has to agree. So how a referral program works is like this. One of my clients comes to me and goes, hey, I want to move or I want to buy a house in Miami. I say, okay, let me get you an agent that I trust. The theory is my client trusts me, and if I trust that agent, then that client's going to trust that agent as well. So I would call down to Miami and go, hey, send you one of my clients going to buy a house in Miami. But before we give you his information, are you going to pay a referral fee? And they would say, yes, we'll pay a referral fee, 25%. Okay, let me send you a form that agrees that you're going to pay me. Once you sign that form, send it back, then I'll give you the client's information, and you call them and go, hey, I'm in Miami. I got your name from Raymond. Let's go buy a house. And then when they buy a house and close, I get 25%. That's how referrals work.
Is that the typical price for referral fees is 25%?
It can be anything you negotiate. I would say first of all, I cannot say there's a typical, because that's setting a market and that's a Sherman Antitrust Act. But yes, 25%. 25% of the fee collected. All right? The client has to agree to that. You can't just ship the client off. He has to say, yes, I will work with that broker. All right? And they have to agree to that. And must have a written agreement with the other side so that I know that I get paid. That way, one is there's proof there was a referral, and two is if there's ever a court case, I can go, well, Your Honor, he signed this saying he owed me, he closed and hadn't paid me yet. Letter H, you are an independent contractor. We've gone over this. Hammer, 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 hammer. You are a statutory non-employee according to the IRS. You are an independent contractor unless we have an employment agreement written. If I hire you to be my assistant, let's say, and I'm going to employ you, even though you're licensed, I would have an agreement saying you are my employee. And for that, I'm taking out taxes and stuff like that. Letter I is basically telling you that you are not a securities dealer. You cannot sell securities. Where that comes from is a lot of times, like a REIT, Simon, even though Simon's thought of as a real estate company, they are publicly traded. You cannot sell Simon a share of Simon's real estate and go, well, it's real estate. No, it's not. It's a stock. You got to have a security. All right? So you can't sell that. Some of the bigger ticks out in Colorado, and I only say Colorado because I know the guys that do this, high end, you buy your tenant in common portion, maybe $10 or $12 million. You got to be careful. Is that a security that they're selling, or are they selling real estate? So, and depends how they built their company as if it's a security or not. Letter J, psychologically affected properties. I used to do that to my kids all the time. I'd go, oh, like in possum. Starts with the letter P, like pneumonia. And they go, what?
There's a book for kids that does that. It's the worst alphabet book ever.
Yes, the worst alphabet book ever. Stigmatized property. A stigmatized property, remember, is a property that has gained a reputation that is generally sought as not favorable. And there are 5. Death, for any reason. Homicide, suicide, natural causes. Commission of felony, gang-related activity. Manufacture of a controlled substance, and the discharge of a weapon by a policeman in the line of duty. All of those are considered a psychologically affected property. Now, here's the key, remember. Well, it talks about HIV as being in there. It's protected, which this can put you in a trick bag. Actually, it's why they came up with this other law, because if they died with HIV, HIV is protected under fair housing as a disability, believe it or not. Yes. So someone said, did someone die in this house? The old law used to be, if I knew, I had to say. But if I said yes, and it was due to HIV, then I'm violating the fair housing by talking about it. It's the old law. Now they've come out with this new method where failure to say yes is not a violation of the law. Now you just cannot give misleading information. So if someone dies and they said, did someone die in the house? You could literally say, sorry, I don't answer those questions.
You ever had to do that?
No, I've never had anybody ask me if someone's dead. And I know for a fact that I've done at least one psychologically affected property because I listed my cousin's house where my grandmother passed away in. So I know Mammal died in the house. All right? But no one ever asked. No, I have never had anybody ask about die. I get more asked about being haunted. Is it haunted? Ask the ghost. I don't know. That's how I think. Welcome to Haunted Hill, or was it Hill House? Welcome to Hill House. So you cannot be liable for failure to disclose. You can't lie, but you don't have to disclose. You could say, we choose not to talk about it. If you said no, that's a violation. You do not have to say yes. You could say, we don't talk about that, sorry.
So even if you knew for sure that somebody was meth created in this house.
And I knew for a fact,
Yes.
and my client guided me to say, I don't want you to answer that. My answer to you would be, if you said, hey, is this a meth house? I would say, I don't know. My client has told me that we don't answer those questions. That's not a violation. Now, you could still force the hand by going, our whole decision is based on your yes or no. My client could still say, we're not telling you. And then you could go, well, then we'll walk away. Okay. If you want to walk away, that's fine.
Wouldn't you have to have actual notice to be lying if you said I don't know?
Would I have to have actual notice? Well, I think you probably would, but his presumption was I had actual notice.
Well, if your client's not the one who experienced
Yeah, but meth houses are actually listed. All right? Or maybe they were the cook. See, that was funny. Nobody got it. Maybe it was their house that were cooking meth in. I don't know. If you have actual notice, you can still say no. You can still say not yes. Sorry. Shiny keys.
Even 3 titles ago, if you didn't know.
If you know, then you know. Like I said, I know because I was at the bedside when my grandmother passed away. I know my grandmother died in that house. I had actual knowledge in that particular case. No one ever asked. If someone would have said, hey, has anyone died in here? I could have legitimately said, we're not talking about that. Well, we think that means yes, so we're not buying. Okay. We're willing to not tell you to and find another buyer. That's fine.
Figure yourself and you don't know.
Yeah. The usual, my answer usually is, dude, this house was built in 1890. Odds are probably yes. You know, in that kind of time frame.
This house used to be a hospital.
Yeah, used to be a morgue. We had one that was a morgue. We did a house that was a morgue. Here comes a problem, number 4. And remember, we talked about this. Once if you're a limited agent, you can see where this trick bag's going because your loyalty to both clients, one of them says you have to disclose everything you know about the property, and the other one says, I cannot divulge anything that would hamper my client's ability to negotiate. I'm put in a position now where I know my grandmother died, and now I'm representing the buyer, and I failed to tell them, hey, you should ask about somebody dying in here. I'm telling you, limited agency, while it is cool because everybody thinks they get paid twice the amount of money, NAR says lawsuits jump 500% on limited agency. Because the first time something goes wrong, who are they going to blame? The one guy that knew both sides. And literally, you do know both sides. For the amount of money that you get to me, it's not worth it. Agency disclosure. This is the written office policy. Remember, before you can talk about agency, you have to explain to them what agency is. Every company has this policy. It's called the written office policy. The written office policy just talks about what agency is, and it goes back to that whole concept I said about the positive power coefficient in a nuclear reactor. We could talk all day about that, but if you guys don't know what that is, I would have to explain it to you first, then talk about it. This is the same thing. Now, number 2, they've got the listing agent, the selling agent, and the limited agents. 1, 2, and 3. We can virtually do these almost simultaneously because the listing agent and the selling agent have the exact same responsibilities except where they don't. Okay? Is anybody watching $1 Million Listing last night or something? I was flipping through channels, and I always like to watch stuff that I know I can only watch 3 or 4 minutes of. Either I'm eating dinner or I'm going to do it. Hey, I can miss it if I'm not going. But he said, oh, this is a beautiful townhouse condo in the top of New York. It has excellent views over the adjacent buildings. I'm like, you're talking about finding ways to spin stuff. Of course it has an excellent view of the adjacent buildings. All right, so you'll see that the listing agent and the selling agent are exactly the same, except in one area where it becomes very obvious. So let's go over 1, listing agent. A, must not disclose the owner will accept less than the listing price. Well, guess what 2A is? Must not disclose that the buyer will pay more. 1B, don't disclose the motivation. 2B, don't disclose the buyer's motivation to buy.
Northside listing, that guy screwed up. The listing agent shouldn't have said that.
Yes, the listing agent should not have said that. He gave away some information that, letter C, must not disclose material confidential information about the owner that would prevent dishonest dealings or hamper his ability to negotiate. Same thing with the buyer. You can't give away something. You can't say something about my buyer, remember that guy just hit the $300 million lottery? That's my buyer. We're looking to buy a house. The seller's going to go, well, shit, then I'm not negotiating low. He's got $300 million. All right? You can't give away that kind of information that would hamper your client's ability. The seller in letter D says must treat the buyer honest and fairly. Well, guess what the seller has to do? Or the buyer has to do? Treat the seller honest and fairly. Listing agents, in your listing agreement, you will tell your seller, I can list competing properties. I'm not your agent only. I'm going to list your house, and guess what? I got an appointment in 20 minutes to list your neighbor's house. So I can list competing properties. The buyer side's the exact same thing. Hey, I'll show you the house, but I just want to let you know at 4 o'clock I'm showing the house to another buyer. I have the right to be multiple agent for different people. So basically, except where one says they'll pay more and the other says they'll pay less, they're exactly the same, your responsibilities as agents. Now, as a limited agent, imagine throwing those two together. That's what you get with a limited agent. Must have written informed consent prior to doing this. So you got to ask both parties. They have to inform that. They have to understand the limitations. You actually have to tell them, you understand, that means I'm going to have to reduce how I help you. And they have to be okay with that. In my opinion, that's where the word limited comes from. Because you become all of a sudden limited in how you help your client. Because no longer can you help them with pricing strategy because you know the other side's lowest price. You can't tell your buyer, hey, lowball them because they're in foreclosure. That's a violation.
That makes sense now. I was always wondering why.
Yeah. It's called limited because you're limited in how you actually help your client. Because now if your client says, what do you think I should offer? All I can literally say is give them the statistics and say, here has what has sold in the neighborhood. You tell me what you want to offer. But if you was my buyer and you were the agent, I would go, hey, dude, I think we should, I heard he's in foreclosure. Let's lowball him, see if we can steal it, and give him 4 hours to respond. I can't do that. Oh, what are you laughing for? That happens.
No, that's right.
We want him to pull the trigger right now and nobody else to get in. That's very common. Yeah, we want to know now. You still can't disclose motivation for either party, and you can't disclose material confidential information. Letter F says you can only show the comps. There's where the key comes in. That's the problem in my theory. I have said, and I'll say it again, I think this should be outlawed in Indiana because you cannot do this. It's impossible. And we'll go back to the example I just showed you. I can't tell you that someone died in this house, so I'm violating somebody's law. If I don't tell you that, I'm violating by not giving you all the information I know. But if I do tell you that, I'm violating their confidentiality. So it's theoretically, in my mind, impossible to do this rule. In-house agency, remember what in-house agency? One of my agents has the seller, one has the buyer. That is called in-house agency. That is not limited agency. All right? I can separate those two agents and talk to them separately. Now, if I have one of those clients, it is limited agent. That's why most managers don't list and buy. All right? I don't want to be my listing and you got the buyer because I know what I know and I now know what you know. That's limited agent. Even though it's technically two people, if the managing broker is one of the two, it becomes limited agency. Non-representation, this is that facilitator, the person that says, hey, I don't know how to fill these forms out, and you help them. Basically, what I say, you had two customers in this deal. For sale by owner, most common. You actually have to say, I don't want you to be my agent. Okay, sign this form. And then sub-agency we have prohibited, so we're not even going to talk about that. It's been outlawed long enough now, you won't even run into it. Let's change the audio.